This is Peggy Clary of Clary Law Offices and chatting again with you tonight on different estate planning topics. And tonight's topic is one of particular importance about your healthcare surrogate and what happens if you haven't done a healthcare surrogate document. And as a quick refresher, a healthcare surrogate document allows you under Florida law to appoint an individual or an alternate person to make healthcare decisions when you're not able to make those decisions yourself. And remember, these are minor medical, diagnostic, not life or death. Florida law, though, has a priority of people that serve as your healthcare surrogate in those cases when you have not executed a healthcare surrogate. And we use the word proxy to identify these people, and it's a helpful tool, but the proxy statute can also be something that you would never want to happen in event you haven't executed a healthcare surrogate. So we call it the double-edged sword, but very quickly, if you haven't done a healthcare surrogate, Florida law says, well, these are the people by law in the following order that can make your decisions. So number one would be a spouse. Number two would be an adult child of the patient. And if you have more than one adult child, they're going to look to the majority of those that can be reasonably available to make the decisions. A parent is number three. An adult sibling of the patient, and again, if you have more than one adult sibling, they go to that reasonable standard who can make the decision and leading the majority. An adult relative who has shown or exhibits special care and concern. Number six, right, there's six, is a close friend, and number seven would be a social worker. And remember, we start at the highest of one and go all the way down. So many of you know, my clients all know, I'm one of 6 children. I even have 2 adult children of my own. And when I think about, and I have 2 surviving parents. When I think about this group of people working through an order of priority to try to make my healthcare decisions, I cringe because I really want to have, as the patient, the ability to name who I want to serve. So for me, making that healthcare surrogate choice is of vital importance. And for many clients or individuals who are not comfortable having this tier of people make their choice, then it is imperative that to defeat the proxy statute, that you take the time when you're able and just do a basic healthcare surrogate that under Florida law says if I can't make my own minor medical diagnostic decisions, then I want the following people or person to be the person that the hospital and the medical staff will recognize as my lawful decision maker. So I hope this little tidbit was healthy on the proxy statute and how it applies to individuals who have not made a healthcare surrogate. This does not mean I don't love my family or my own adult children, but it is imperative that when we're thinking about meeting our healthcare needs and who can make those choices when we can't, that we take the time to plan and nominate people we trust. So we hope you live a life with civility, respect, and dignity. If we can help you at Clary Law review your healthcare surrogate, please reach out, and thanks again for your time.